This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why a mold exclusion that generally applies to mold damage is not covered even when the insured bought a biological damage coverage that still could not overcome the general mold exclusion. In Clay Buchholz and Lindsay Buchholz versus Crestbrook Insurance Company, a Fifth Circuit Court of Appeal decision of April 18, 2023, Clay and Lindsay Buchholz sued their insurer after receiving $745,778 for damage to their 10,000 square foot house in Austin, Texas. The Buchholzes insured their home with Crestbrook Insurance Company. Their policy included biological deterioration or damage cleanup and removal coverage, sometimes called the mold coverage. The Buchholz family discovered a widespread mold infestation in their home. Although Crestbrook covered many of their losses, it denied a generalized claim for mold growing in the Buchholz's walls and heating, ventilation, and air conditioning systems. A magistrate judge issued a report and recommendation in favor of Crestbrook, and the district court adopted the magistrate judge's conclusions. Crestbrook paid the $745,778 for covered losses on 5 of the 6 claims submitted. However, Crestbrook asserted that the 6th claim for general mold growth and mold in the HVAC system was excluded. The Buchholz family retained M-Law Forensics, Inc. to investigate the cause of their mold infestation. Crestbrook paid for M-Law's investigation, and Dean R. Reed, a professional engineer, wrote a causation report on what he concluded led to the mold growth at the Buchholz's house, that found that discrete leaks and a global issue due to interruption or restriction of the moisture vapor drive drying process caused the mold. Specifically, he concluded that the house's HVAC system was improperly designed or configured and non-functional, which resulted in elevated moisture content and subsequent mold growth. Based on M-Law's causation report, Crestbrook denied the Buchholz's mold claim. The denial letter referred to policy exclusions for biological deterioration or damage, a defect or inadequacy in design, workmanship, construction, and materials. In addition, the policy contained exclusions for weather conditions or dampness, and gradual or sudden loss due to a mechanical breakdown. Crestbrook concluded that the biological deterioration or damage additional limited coverage would not apply to this claim. In their final complaint, the Buchholz family alleged that Crestbrook breached their insurance contract in bad faith and violated the Texas Insurance Code. The magistrate judge concluded that the Buchholz family had failed to demonstrate a covered cause of loss as required by their mold coverage. Under Texas law, when deciding a dispute regarding insurance coverage, the court first looks to the language of the policy because it presumes parties intend what the words of their contract say. The court must give the policy's words their ordinary and generally accepted meaning unless the policy shows the words were meant in a technical or different sense. A disagreement between the parties regarding the meaning of a policy term or interaction between terms does not create an ambiguity. The insured's burden in a coverage dispute is to prove that their loss falls within the terms of the contract. Once the insured demonstrates this, the burden shifts to the insurer who, to avoid liability, must show the loss falls into an exclusion to the policy's coverage. The Fifth Circuit concluded that the magistrate judge correctly laid out the Texas insurance dispute burden shifting framework in her report and recommendation that concluded, quote, the Buchholzes failed to identify the cause of the mold damage. Instead, the Buchholzes submit that the policy is an inclusive all-risk policy that covers all risk of accidental direct physical loss to the property unless an exception applies. Accordingly, the Buchholzes failed to meet the burden to show that the mold claim is covered under the mold coverage provision. In its motion for summary judgment, Crestbrook argued that the mold infestation was an excluded peril under the policy. Applying the Texas burden shifting framework, the Fifth Circuit agreed with Crestbrook that the mold exclusion bars coverage for the Buchholz family's claim. Under the Texas insurance dispute framework, the Buchholzes must first show a direct physical loss as required under their policy. Then Crestbrook can identify any exclusions to coverage of that loss. The policy excluded coverage for loss, quote, to any property resulting directly or indirectly from any of the following: biological deterioration or damage except as provided by the mold coverage, close quote. The Buchholzes showed they suffered a mold infestation, nothing more. Their theory was that the water intrusion causes mold, but water intrusion as such is not a loss covered by the policy when its only manifested harm to covered property is fungal growth. Consequently, the Buchholzes did not show that their mold coverage serves as an exception to the mold exclusion, so their generalized mold claim was excluded by the terms of their policy. Although the Fifth Circuit found that the district court incorrectly applied the Texas insurance coverage burden shifting framework, Crestbrook was still entitled to summary judgment because it had demonstrated that a generalized mold claim was excluded under the policy. In my opinion, the Fifth Circuit concluded that it was required to interpret the insurance policy as it was written, and the generalized mold claim was clearly and unambiguously excluded. Nothing more needed to be said. The Buchholzes should not have sued their insurer. They should have sued the contractor, the designer or manufacturer of their defective HVAC system, which was responsible for the mold. In fact, the Buchholzes and Crestbrook should work together to litigate against the designers and builders of the system so that they can recover the monies already paid to the Buchholzes, and the Buchholzes can recover the additional damages that were not covered by their policy. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and will receive notice of every new blog postings, usually 5, sometimes 6 a week, and you will have access to the more than 4,500 blog postings. If you enjoyed the blog and found it useful, or the videos on rumble.com and youtube.com, please tell your friends and colleagues so that they too can subscribe to the blog and to the videos. The videos are also available free to anyone who contacts them, and views the video, and you can subscribe to the videos as well as to the blog postings. And if you wish additional detailed information on insurance claims and insurance coverage, please consider subscribing to my Locals community or my Substack publications. Thank you for your attention.